Good evening, Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live Weekly Update. I got a couple of things in mind I'll go through. I think I'm going to try to go through 6 items instead of 3, or I'll never catch up with this long list that I've compiled. The other thing I want to talk about is the submission I made to the Office of the Veterans Ombudsman and the Canadian Forces Ombudsman today after I did a poll, which wasn't a poll. It was asking for permission to submit a complaint with more than just me. So 73 people clicked yes. So I told the Ombudsman it was me plus 72 other people asking for an investigation into the Service Income Support Insurance Plan. Now, without further ado, number 475 on my numbered list that's in the files section of my group. Punishing success. For example, having a long-serving Canadian Forces member has been more loyal than one who has served less time, but clawbacks punish this loyalty. Now, what I'm getting at is that even to get a Disablement Canadian Forces Superannuation Act pension, you had to have 10 years instead of 2 years that you had to have for a public service and an RCMP Superannuation Act pension. But what I'm getting at as well is that anybody who has a very high pension won't get any SISP or income replacement benefits, because they have high CPP or high Canadian Forces pension, so they get punished for being more loyal to the Crown. And I don't think that's fair. Certainly not legal. Number 476, did Canada Pension Plan pay flat rate retroactive? Now, flat rate is something that is a part of the Canada Pension Plan Disability. It's been part of it since 1966, but it was a very low amount up until 1987. Now, in 1987, it got increased to 3 times as much as it was in 1986. And that caused the insurances and the governments across the country to perk up and decide to claw back Canada Pension Plan Disability because they weren't doing it before, according to Michael J. Prince in a book that I found on Google Books. Number 477. Like I said, I'm trying to wing it, go a bit quicker on these instead of going in detail too much. Workers' compensation into account. Damned if I know what I meant. But the thing is that workers' compensation, never gotten it, but it's an exchange of the right to sue in tort for the right to comprehensive and administrative compensation instead of legal compensation that you had to prove to a judge. Number 478, keeping costs low. Now, this plays right into what I was thinking about talking about tonight anyway. The Organization of Economic Cooperation and Development, the OECD, VAC reference paper, etc. Now, the people that pay insurance, whether they're a for-profit insurance company or an employer who has a self-insurance, like the federal government has for the Service Income Support Insurance Plan, they want to save money. They want to keep costs low. Now, in a 2010 report by the OECD, they said that in Canada, the average person only got long-term disability for about 48 months, 4 years. And yet, if you look at, say, the 2013 Office of the Veterans Ombudsman actuarial report, their estimate of the cost wasn't for 4 years. It was until age 65. So, when you put false numbers into an equation, you're going to get false answers. So they estimated how much a person will get until age 65 when the benefit would stop, but that didn't factor in that the benefit wouldn't keep going anyway past 4 years. I was thinking of doing in number 479 a column on bad public policy. I'm always talking about it. Clawbacks are bad public policy. Why are they bad public policy? Well, the Canadian Forces Superannuation Act pension gets clawed back by the Canada Pension Plan Disability being used to reduce the Canadian Forces pension. Now, pensions, in all cases, but there's a case called Roy, Federal Court of Appeal 2002 or 2003, and that case was about a divorce. And it was talking about the purpose of the Canadian Forces Superannuation Act, and it said that it was to a forced savings plan, in other words, property, as well as a recruitment and retention device used by the government. Now, that was also mentioned in the Nolan Supreme Court of Canada 2009 case a few years later. They talked about the benefits that the employer gets from having a pension, encouraging people to stay with the company and to join it in the beginning. That's recruitment and retention. Now, in the military, it's especially important because past research has shown it's about $250,000 to train a soldier. So if you kick one out for becoming disabled, then you had to pay $250,000 to train a new person. Number 480, and I really am winging it on these tonight. Independent actions. The contract and charter, for example, have different remedies. Now, sometimes when you're looking at damages, they look at, was there an independent actionable cause? Now, one of the things about these things, and again, I'm not a lawyer, but I've read a lot of law stuff. In order to have a lawsuit, you had to have a cause of action. You had to have something that happened. You have somebody that has to have a duty of care to you. They had to be careful, and they breached that duty of care, and they injure you. Now that triggers a cause of action, a remedy in a tort lawsuit. Now, workers' compensation replaced a tort lawsuit. The Pension Act replaced a tort lawsuit. And it is open for discussion whether the new Veterans Charter, the Veterans Wellbeing Act, it replaces a lawsuit in tort because they don't follow the same principles. For example, Section 25 of the Pension Act mimics the compensation principle of tort lawsuits in that you cannot get more than 100% of what you lost. But it doesn't claw back the Canada Pension Plan. It doesn't claw back the Canadian Forces pension. But the new Veterans Charter income replacement benefit claws back those payments which cannot be clawed back in a tort lawsuit because they are non-indemnity and contributory. So because they are not meant to compensate, that's what non-indemnity means, that means you can't factor them into account. Now, that was a quick 6 points from my numbered list. So after I save this, I'll go back to my group and I'll look at the post I made about my complaint report, I'd call it, really, not a complaint. I'll explain what's up. So, let me see where it is, because sometimes I find all the stuff I put in there over the years, I put a comment in the older posts when I'm searching for something, and that moves it up to the top. So now I have to go through my items that I moved up because I did that. So it makes things a bit slower when I'm doing this, when I'm doing that. Now, where the hell is it? Anyway. Okay, so I keep thinking that's what I'm looking for because I see something about the Ombudsman, but again, okay, so here's the post I made. I did it 10 hours ago. I said the body of the complaint I submitted to the Canadian Forces Ombudsman will copy and paste, I said past, I'll go fix that now, to the Office of the Veterans Ombudsman. Now, the thing is that I don't really expect much from these organizations. I think they're genuinely, completely a waste of money. My research in the past has shown that they have a budget of about $5 million a staff of about 30, and it seems like they can't find their, oh geez, I can't remember the whatever with their ass. Anyway, I said I want to have a neutral and thorough investigation of CISA Policy 91102 is required to restore some trust in the alleged contract of insurance. Contact me as subject matter expert or SME on this for further details. I suggest a joint investigation with the Office of the Veterans Ombudsman, OVO, due to overlapping jurisdiction. Some extremely obvious reasons for this are: 1. A 2% cap on cost of living allowance, which is contrary to public policy. 2. Duplicate clawbacks with Veterans Affairs Canada and Canadian Forces Superannuation Act, resulting in harm to Canadian Forces members. 3. Harm to the national defence public policy by reducing recruitment and retention. That's what I was just talking about before. More available on request. I did a poll on Facebook in my main group observation post, and 73 people responded to my request that I submit a group complaint. Sent the complaint to the Office of the Veterans Ombudsman. I called the Office of the Veterans Ombudsman. I had a 22-minute call with a lady named Stephanie. And I told them I was filling up the online complaint. I said I advised that the warning about callers not to be rude is an insult in reality, as no such warning is really needed. It should be a notorious subject that you don't treat people rudely on the other end of the phone. So by giving you a warning, it implies that you will be rude. Okay, they shouldn't be doing that. I asked about the RISB, or RISB, Retirement Income Security Benefit complaint I submitted a few years ago. I haven't heard anything back. I gave a lecture on privacy as the agent was about to say something that I was sure would trigger me. Canada Pension Plan, or I linked privacy to my new complaint. A. The Department of National Defence, which is the Crown, collects personal information about Canada Pension Plan disability, for example. B. There's a program arrangement that's signed between the Department of National Defence and Veterans Affairs, and it says that they will both collect their own consent forms, which contravenes public policy as the Crown already has that information. C. Advised sharing information with DND and VAC would lower the chances of harm coming to the veteran due to multiple clawbacks of things like the Canada Pension Plan disability, for example. D. Advised that it would save the taxpayer money to collect information only once instead of more than once, which is good public policy. Then I put in here a general comment. Double-dip clawback and triple-dip clawback are very bad public policy because it informs the public that equity or fairness does not matter. Strict application of the law or contract will happen again even if it hurts the veteran. Equity law was developed to avoid this. The Canadian Forces Ombudsman report in 2003 focused on equity, not law, for a good reason. If this double or triple deduction is allowed to continue, they will be telling the public that they can do it too. Right now, they don't do it. Now, I often get this mixed up, but it's the Canadian Life and Health Insurance Industry Association, or it's the Canadian Health and Life, CLHIA, or the CHLIA. Now, they have a policy that when two agencies want to intercept the Canada Pension Plan disability, for example, they don't each take 100% like the government does. They take 50% each, maybe. In that way, they don't piss off the insured person, who would then go to the media or the Member of Parliament and complain that, oh my God, I'm losing more money than I got. Which is the truth. That's what's happening. See? Now, the thing is, okay, the other point, I went through this and I went faster than I thought. So I'll go through some points about the Manouche case affidavit, because there's a lot of mistakes that were happening in the Manouche case, and people might not realize it. Now, the thing is, one of the things that I want to happen in the Canadian Forces Ombudsman or the Office of the Veterans Ombudsman is to answer such questions as, who insures the policy, who underwrites the policy. Now, that's a rhetorical question because we've already heard that in the Manouche federal court case. And they said that the chief of defense staff was the underwriter of the policy. Now, even though that was ruled on in court, when I talked to Manulife, they said that they underwrote the policy. So there's a difference of opinion, but they're not really a difference of opinion because this is a fact, because it was ruled on in a court of law. When you have something that goes before the court and it is disputed beforehand, after both parties present their arguments and the judge decided that it goes this way and not that way, it's 100% true, and the other party can't say it's not because they had their chance in court. So the thing is that, you know, they shouldn't be trying to use something that failed, an argument that failed. So anyway, another thing I want to put into these people, because they keep talking about income replacement benefits. CPPD is not bought for income replacement benefits. It's bought for peace of mind. Now, you get the peace of mind through a payment of insurance. But if they don't pay it to you because they won't approve you, or if they claw back so much that you don't get any money, then you don't have any peace of mind. Now, the thing about breaching someone's peace of mind in this manner is that you can end up paying a lot of money if you're the one who breaches the peace of mind. So you're not only putting yourself on the hook for possible having to pay people back, but you're putting yourself on the hook for paying punitive damages. Now, punitive damages are designed to punish. They're designed to stop people from doing something in the future that was so egregious, so bad, it shouldn't have happened in the first place. So anyway, I'm getting there. I'm looking at the stuff here from the affidavit, and I'm getting down to where they put in, the Department of Justice lawyers put in a bunch of garbage. Okay. So this is the defendant's memorandum of fact and law, and the lawyers for the government was John H. Sims, Deputy Attorney General of Canada, and Laurie Ransom and David Shapiro of the Department of Justice. When they started talking about things, though, they talked about, they said, okay, I'm looking down for the headings that they used. Availability of damages in a charter claim. Well, charter claims are supposed to go to a court as per Section 24B of the Charter of Rights and Freedoms. And generally, charter damages are pretty low. But they are available. Now, next one they said was ultra vires or illegality. So they said in paragraph 50, the defendants claim that Section 24A.4 of the CPPD policy, which deducts the amount of the Pension Act benefits from the CPPD long-term disability benefits, is unlawful and therefore ultra vires, is based on the assertion that offends Section 31 of the Pension Act, which states, no award shall be assigned, charged, anticipated, attached, commuted, or given as security, and the minister may refuse to recognize any power of attorney granted to a person with reference to such payment of an award. Now, here's the problem, one problem that I have with this assertion that the Department of Justice made, is they're trying to say they're not breaking a law that they wrote or helped to write. So in the past, when the government was putting the Pension Act into law, the Department of Justice would have been given the duty to write the law. And they wrote Section 30. And they wrote it to deny creditors from getting the pension, either directly or indirectly. Now, I just realized, because I never read the word equity that time, that they left something out, because it states in law or equity. Anyway, paragraph 51. The plaintiff claims that paragraph 31 of the amended statement of claim that the SISIP provision for reduction of the pension by the amount of the Pension Act benefits, which he erroneously terms a clawback, effectively operates to assign and anticipate the receipt of the Veterans Affairs Canada disability pension contrary to section 30(1). He further claims that the paragraph 33 of the defendant has unlawfully seized and executed upon the Pension Act benefit. Well, you see, they're trying to pull a fast one by trying to rely on legal technicalities. And they then go on to say, the following definitions appear in Black's Law definition. To assign means to transfer, make over, or to act over to another. Now, in the Financial Administration Act, which McInnes Cooper did not mention, but ignorance of the law is no excuse, so the Department of Justice lawyers and McInnes Cooper and the judge should have known about Section 67 of the Financial Administration Act. It says that we are not allowed to assign a Crown debt to somebody else. Okay? So, the Pension Act pension is a Crown debt payable to the pensioner. And you're not even allowed to use it as security for a loan or a mortgage. It's just against the law. Excuse me. A little bit of that stuff I had with the sinus infection still with me. So, the thing is they try to get on with this Black's Law dictionary, which everybody doesn't have, by the way. Okay, so anticipation, they say, is the act of doing something or taking something before its proper time. Seize, to take possession of, or forcibly to grasp or snatch, or to take. Execution, a formal process which an official, usually sheriff, is directed by way of appropriate judicial writ or seizure to sell as much as for the debtor non-exempt property as necessary before to satisfy judgment. You see, they're being cute here, because when they enact or act upon a clawback provision in a contract, they're avoiding court. They're doing something without the sanction of the court. Now, normally, you can't do that. If someone says you owe money, they have to prove it in a court of law, and after they do that, then they can collect on it. But these assholes are acting like the government does for income taxes, and they wrote a law in the Income Tax Act, and they said that every notice of assessment that they send out is considered to be a federal court judgment. But there's nothing like that in the SISIP policy. So they shouldn't be trying to collect on something before it goes to court, because if this went to court, the judge would say, get away from here, you can't do this. Because it really is true that Section 30 of the Pension Act is supposed to protect the money from creditors. Now, the thing is that there's a very important analogy, like the workers' compensation laws in Ontario and Newfoundland and all the other ones, and they say that nobody can touch the workers' compensation payment. And that's because it's a replacement for a lawsuit and tort. And Section 30 is because it's a replacement of a lawsuit and tort, plus it has something to do with residual Crown immunity. You couldn't even get money out of the government up until 1953 when they brought in the Crown Liabilities and Proceedings Act. So anyway, so they say this bullshit that I was reading recently in another case. It is submitted that the plaintiff at all times, material times, continued to receive his entire Pension Act disability pension. It is not possible for him to make out a claim that the Pension Act was assigned, anticipated, seized, or executed on. No. I'll refer to a case in 1995. There was a person who owed $300,000 to his ex. Now, it was a divorce case. Now, he left the country, and the only asset he had left in Canada was a public service superannuation pension. So now his X did not like that. She couldn't get the money she was owed. So she went to court. She asked that the pension be liquidated so that she could get her money. Now, the Department of Justice decided to intervene in that case because it mattered to the Crown. And they said that the lady was trying to do what was basically an extra legal garnishment or attachment or seizure. So it wasn't allowed, they said, because of laws that the Crown put into place. And they said various parts, like Section 36 of the Old Age Security Act, or Section 42 of the Employment Insurance Act, or Section 10, brackets 10 of the Public Service Superannuation Act. So Pension Act Section 30 is the same type of law as those that were cited by the Department of Justice lawyers in 1995, which was more than 11 years, 17 years before the Manouche case settled up. But this affidavit I'm reading is from 2008 or 2009, so it's 13 years after. Now, is there no institutional memory at the Department of Justice that they decided to conveniently forget about their position when they intervened in the Beattie versus something Ontario Superior Court 1995 case? Lattisaur, I think it is. Beattie versus Lattisaur. That stuff is worse than usual now. I'm talking too much, I think. So anyway, the thing is, though, let me get back to a legal principle in the common law. Now, if you sue or get sued someone and they get damages or you get damages, Canada Pension Plan Disability is what they call a non-indemnity and contributory payment, and you are allowed to get your damages plus your non-indemnity payment because one repays you for what you lost and the other one is something that you bought and paid for. Now, with that in mind, you see, under the Pension Act, they didn't claw back the Canadian Forces pension and they didn't claw back the Canada Pension Plan. Now, in the CPPD policy, they do claw back the Canada Pension Plan and they do claw back the Canadian Forces pension, even though CPPD is a non-indemnity payment itself. Now, when you think about a non-indemnity payment clawing back an indemnity payment, which is what the Pension Act is, you are comparing apples to oranges. Now, that was used, that analogy was used in the Manouche case, but they had it backwards. They said that the CPPD policy was an indemnity for your lost income, which is false, because it's paid in a formula, in a contract. It has no bearing on your actual loss. So what they were doing was much worse, in fact, in my expert opinion, than someone who has to pay damages asking to take CPPD into account. Well, they're trying to get away with something, but they're trying something novel. They're trying to get the non-indemnity payment to reduce their indemnity payments that they had to pay in damages. But these fuckers decided that they were going to take an indemnity payment and reduce the non-indemnity payment because of the indemnity payment. Now, the indemnity payment is supposed to make you whole. So if you lost a leg, you lost 2 legs. You get a pension. That money is your legs. So when CPPD was deducting the value of the pension from the insurance money, they were taking the monthly payment that you were getting for losing your legs into account and reducing their insurance. Downright fucking despicable. Don't understand how they didn't get thrown in jail. So anyway, the next point, because I don't want to get bogged down calling them names, because they are fuckers and I hope they go to hell. Somebody who will steal the money from someone who is injured in service in their name deserves to rot in hell. I think that's a very good opinion that people should subscribe to. Public law duty. Now, the plaintiff claims that the defendant has a public law duty to fulfill its obligations under the Pension Act, and that the reduction of the Pension Act assisted long-term disability by the amount of the Pension Act benefits breaches that duty. Now you see, I'm looking down through it, but I would say that it's certain that they breached their public law duty, because who's going to enforce Section 30 of the Pension Act except Veterans Affairs Canada? So CISIP's trying to take the money into account. So Veterans Affairs Canada should have took them to court or sent them a very stern letter and said, get your fucking hands off that money, because we have a law that protects that in Section 30 of the Pension Act. Now, you have a contract and you say you can take it into account. But you know something that trumps a contract? A law. So you can't put something into a contract that violates the law. Or I could have a contract with you and I could say the payments that we are making are not subject to the Income Tax Act. If they had to listen to what was in a contract and ignore public law, people could write laws to suit themselves. Now, going down through this garbage can't help but make the odd comment. Number 58, paragraph 58. CISIP long-term disability is an income replacement plan which is provided in addition to any award owing under the Pension Act. Now, it's interesting that they say it's owing, because that's one of the things that I've been harping on recently, is that when you're owed compensation, both the Pension Act and the Veterans Wellbeing Act said that there's an obligation owed, a debt owed, to the person injured in Canadian military service. Now, this could come up about taxes, for example, because they tax the Pension Act under the table, and they base it on the after-tax income of a public servant. But the Veterans Wellbeing Act, they tax that openly. So they put in there, in Section 6.1F of the Income Tax Act, F.1 actually. You don't think I'm going to last much longer with this throat the way it feels. They put in there, in Section 6 of the Income Tax Act, and then you have subsections like Section 6.1F, which is taxation of CISIP, and Section 6.1F.1, which is taxation of the income replacement benefit. They say that these are fringe benefits of employment. Now, Canadian Forces members don't have an employment contract. Public servants do. They have what's called a collective agreement that the union negotiates on their behalf. So you might tax, say, the Sun Life policy under Section 6.1F, but you can't tax CISIP, and you can't tax income replacement benefit under the fringe benefits clause of the Income Tax Act. Go fuck yourself. What they ought to be doing, and this is a fallback position, they could look at it as a form of workers' compensation, and that is not taxable under Section 110 of the Income Tax Act. Now, it's kind of taxable because they use it for income tested benefits. They include it on your taxes for income tested benefits so that they won't waste money giving it to you. But then they take it off again before they charge taxes against the remainder, whatever. But that would be better than the existing bullshit where the government mitigates its damages, because that's the allegation I'm making. The government is abusing the Income Tax Act by mitigating its damages, because workers' compensation is a replacement for damages, and the Pension Act is a replacement for damages, and the Veterans Wellbeing Act is probably a replacement for damages. But they're taking into account things that are not supposed to in damages, and then damages are not taxable, but they're taxing the income replacement benefit on CISIP. So if you want to replace a lawsuit and tort, you have to follow the same principles as a lawsuit and tort. I mean, it won't be exactly the same, because other than that, you just have the lawsuit and tort instead of replacing it. But you don't water it down. For example, J.D. Irving, New Brunswick Court of Appeal in 2012, they had the Canada Pension Plan reducing workers' compensation. It was ruled to be unlawful. one of the main reasons it was unlawful is they said that the injured worker is not supposed to fund their own disability. That's a principle of the Merida principles, which have to do with workers' compensation. Now think about the fact that the government won't pay you income replacement benefit if you have Canada Pension Plan or the Canadian Forces Pension or CPPD. So you're funding your own disability, which is insane. You are not supposed to. They took your right to sue. You're not supposed to then subsidize them further. It's supposed to be a fairly even exchange. Now, let's go back down. I am getting tired, so maybe I'll call her quits soon, but okay, Charter Section 15 is the next heading that the government says they're not breaking. The plaintiff claims that the operational assistance policy 04A4 breaches Section 15 of the Charter in two ways. One, members of the Canadian Forces who are able to work while disabled are able to collect the Pension Act benefits on top of their salary. Two, as of April 2006 under the new Veterans Charter, disabled Canadian Forces members receive a disability award as a lump sum, which does not reduce their long-term disability. Now, see, I wouldn't have used that at all. That sounds like a stupid argument. I would have said, Charter Section 15.1 is designed to protect enumerated groups. There are 7 groups, one of which is the disabled. Now, these are called minorities because they're very rarely, going to be the majority. So you have to have special protections for minority groups. Now, when you put into the contract of insurance a clawback based on disability, well, you're getting assistance because you're disabled, and you might be getting a Canada Pension Plan disability because you're disabled, and you might be getting a Canadian Forces Superannuation Act pension, disablement pension because you're disabled. Well, they put a burden in or under the law, which is what's prohibited in Section 15.1, in the clawback itself. So, by clawing back the money being received because of disability from another payment being received because of disability, you just breached the Charter because you placed a burden that you didn't place on another healthy person. You put it on the person because they were disabled. So, I don't understand how people don't see what, to me, seems to be common sense. To try to argue that it's because that the Canadian Forces member gets their money plus pay, that's a non-flyer. That's not a non-starter. You're not going to win on that argument. Why not? Because it's coming under 2 separate payments in different circumstances. You get your pay for service. Your salary, your pay, your remuneration is in respect of your service. The Pension Act payment is being made in respect of an event that causes disability in service. It has nothing to do with your service, but it has to do with the event that causes a disability in service. It's not paid based on your rank. It's paid based on the table of disabilities, and up until the year 2000, the government had an unlawful, I would call it, restriction on that you couldn't get your pension while you're serving. But you see, in a similar situation in the workers' compensation field, an injured worker who was still able to work, they get a permanent partial disability award in addition to them being able to work at their leftover earnings capacity. In fact, I mean, if you ask me, it's awful close to the income replacement benefit, the earnings loss benefit they used to call it, because they look at what is your percentage of your old job to try to figure out how much you can still do. Like it's residual earnings capacity, I think it's called. So anyway, let me see if I can do one more point, and then I'll probably call her quits. I'll do this last one, unjust enrichment, okay? Because this one has really pisses me off. I don't know why the Department of Justice lawyers try to pull the wool over people's eyes about what is the cause of action in equity known as unjust enrichment. The plaintiff, in paragraph 66, the plaintiff alleges that the defendant has been unjustly enriched as a result of the application of the SISA reduction. He alleges that the defendant has unlawfully retained benefits to which he is entitled to his detriment and without any juristic reason. Now, they just covered the main elements of unjust enrichment. They are that you are deprived of something, somebody else gained something, and there was no juristic reason for that to occur. Now, a juristic reason isn't a law, it isn't a contract term, it is about justice, okay? So, they had to argue about fairness and not strict legality. So, paragraph 67, the Supreme Court of Canada has repeatedly held these three requirements must be satisfied before it can say that an unjust enrichment exists. These include an enrichment, a corresponding deprivation, and the absence of any juristic reason for the enrichment. Then they quote Sriracha versus Sriracha, 1986, Supreme Court of Canada. Now, another thing that might be missed here is a lot of times, if not every time, you had to have fiduciary duty to have the unjust enrichment, I believe. These assholes. Paragraph 68. First, there has been no enrichment of the Crown. Well, how competent are you, Department of Justice lawyers? Have you ever heard of Peel, Supreme Court of Canada case, where they said there can be two types of unjust enrichment? There can be a negative unjust enrichment when somebody saves, do not pay a payment that they would have paid. And then there can be a positive unjust enrichment when somebody receives money they shouldn't have received. So a clawback is a negative unjust enrichment because they withhold their payment based on another payment that has no bearing on the matter. So therefore, they are guilty of unjust enrichment. The funds held in SISA are held strictly for the purpose of the payment of the SISA benefits. Who gives a fuck? That's a moot point. Why are they bringing it up? They can be used for no other purpose. But you see, here's the thing. What they're not saying is the funds held, well, they say by SISA, but it's really being held by Manulife. The funds are being held to pay claims. Now, if you claw back something like the Pension Act, then you don't have to make as much money payment out of the fund. See? So if you save on the money that you're saving being paid out of the fund, then you save because you don't have to put as much money in to cover future claims. I mean, I can't believe I got to spell this out in excruciating detail. Similarly, were SISA to become underfunded public funds, public money collected and placed in Canada's Consolidated Revenue Fund would not be available to provide SISA benefits. What the fuck are they talking about there? Look, Summers versus Freedman, Supreme Court of Canada, 2002. It said that the insurer is expected to set the premium price at whatever it wants to. So let's just talk about underfunding, okay? You look at how much money is coming in, how much money is going out. You make actuarial decisions. You invest it. You do different things. There's no such thing as underfunding here. I mean, if they set the premiums and they have to, try to, if you're any good at business, you should be able to make it work. Unless, of course, you're an idiot and do something like what they did. Because eventually they had to pay it back. There was $1.9 billion that had to be paid over 10,000 disabled veterans after the Manouche case. Now, the bulk of the money was paid fairly close to the decision. But then they, in their press release, they said it was, $700 million after, between 2012 and 2017 or 18 or something like that. So, what they would have us believe is that nothing to see here, there's nothing going on. No crime has been committed. Now, I said crime on purpose. in Canada, there is criminal code violations for wearing medals that you have not earned, or wearing the Canadian Forces uniform when you're not in the military. If you do that, you are subject to criminal prosecution. If you get caught, I suppose. You tell me that stealing the money from a disabled veteran who has been disabled in Canada's military service is not worse than that. It should be a fucking crime. And I can link to the crime that it could be. It could be two that I can see. Section 122 of the Criminal Code defines a crime called breach of trust by a public officer. The elements include a couple of boilerplate points, but then you get up to the last two, and like they ask, what was the expected conduct of this public officer, and then how did this action breach the standard that was expected for the public officer. Now, the criminal code between section 120 and 126 is the good government section. And the government put that in there to assure the public that the government wouldn't be corrupt. So, the other one is section 126. Section 126 of the criminal code is a breach of a federal statute. But it's not every law that this could apply to. It's only those that do not already have a criminal sanction. So, if you breached Pension Act, Section 30, and Pension Act Section 30 did not say that if you breach this section, you can be subject to a fine or jail time or whatever. You can't use the criminal code if that was in the Pension Act. But because it's not in the Pension Act, you need to have a catch-all law to enforce laws, because if you don't enforce laws, people won't obey them. So when somebody claws back the pension when they shouldn't have, like they did for 1976 to 2012, for 36 fucking years, these people stole the money from disabled veterans. Now, I think people should go to jail for that. Now, no one charged them. No one probably ever will be charged for breach of trust or breach of a statute. The only couple of instances that I ever did see was I saw one case where Canada Post was on strike in 1978 or 1979. The government legislated them to go back to work. Back to work legislation, and the union stuck their nose at the government. Not only did they get charged with Section 126, breach of federal statute, but they also got charged with criminal conspiracy. So they got found convicted of two or more people that agree to break the law. That's a criminal conspiracy, Section 435 of the Criminal Code. So they got found guilty of breaching that law, and it was more than one of them. So they got charged with two different crimes. The people that are doing this, like the program arrangement, okay. Back in 2006, the Department of National Defense and the Department of Veterans Affairs and CPPD Financial Services, three agents, three members of the government, got together and they agreed to, in a signed agreement called the program arrangement, in section 3.1.2, they said that CPPD Financial Services will be the first provider of income replacement upon a medical release. Now, this is against the common law because CPPD is a non-indemnity and contributory payment. It's against common sense because the person paid for their insurance. Premiums are deducted from pay for the long-term disability insurance. And yet, Veterans Affairs Canada gets subsidized by the person's own insurance paying for their disability first, which is a breach of the merit principles of workers' compensation. So the injured person is not supposed to fund their own disability. No, that's only when someone else hurts them. If you get hurt on your own, well, you got to fund your own disability, obviously. But when someone else injures you, which is the concept of the tort lawsuit, or if something replaces a tort lawsuit with workers' compensation or the Pension Act or the Veterans Wellbeing Act. You can't very well say you replace the lawsuit in tort and take the right to sue from the injured person if you then ignore the principles of tort law that says you don't have to fund your own disability. You see? I mean, people look at me like I'm crazy sometimes, but I mean, I can't help it. It's logical. Anyway, listen, getting dried out here, my throat's coughing up all this red crap. Thanks for watching. I'll see you next week.